So I'm going to first kind of give an overview of the Office of Professional Conduct to give you some context as to the realm in which your attorneys are operating. And I do call them your attorneys because as an attorney, we don't survive without paralegals and assistants. And then I'll go into some of the rules and specific rules that you may encounter that can cause your attorney some issues. If at any point you have questions, please raise your hand and let me know. I feel like this might be a little more informal than some of my other presentations. And I'm not the best at doing PowerPoint presentations, so the slides may not be exciting, but the presentation will be. So the regulation of the practice of law is given to the Supreme Court through the Utah Constitution, and the Supreme Court has bestowed that authority over the Office of Professional Conduct. The Office of Professional Conduct, the OPC, is no longer part of the Utah State Bar as of this last March. We are governed by an oversight committee of the Supreme Court. And it's a transition that is taking a lot of people some time to understand, but we are no longer part of the bar. And that is to alleviate some of the conflicts that are involved with having the Bar Commission kind of oversee what we do, just based on the disciplinary duties that we have. So the disciplinary process, I'm going to talk about three different things: where complaints come from, what happens when the OPC receives information, and then outcomes that can stem from complaints. So complaints can come from anyone. We've had them from clients, from opposing parties, from opposing attorneys, from paralegals, from assistants, former employees, from the general public, from family members. It can come from anyone. And that is because we have a duty to investigate misconduct, and we can't really rule out where the evidence of that misconduct comes from at the beginning. The bottom one, the NSF, that is a non-sufficient fund. When attorneys sign up for a trust account, and I'm going to get more into trust accounts later, but how many of you deal with money or trust accounts in any way? You do, okay, a couple of you. For the rest of you, it'll just be good knowledge to have. For some of you, it'll be particularly relevant. So when an attorney signs up for a trust account, which is where they put all of their client money that they have not yet earned, the bank, they sign basically a permission for the bank to report to the Office of Professional Conduct if that trust account becomes overdrawn. Because that account should never be overdrawn, because it is client money that should not be taken out unless it is earned or unless it is designated to go somewhere else. And we get quite a few of those. A lot of them are innocuous and are simply a bank error or a mistransaction. Some of them are misappropriation of funds, meaning the client has, or excuse me, the attorney has stolen client money and tried to hide it. The third one, OPC, we can open cases, and usually we open them if we see something in the media or something that comes from the court. We can open them on our own behalf. So when the OPC receives information, it comes in various forms. Some are better organized than others. We take that information and initially review it to see if it implicates any rules of professional conduct. We then notify the attorneys, and then we ask the complainant, who is the one that submitted the complaint, for additional information or evidence if there's nothing there quite yet. Then we'll go back and forth asking for responses and replies to kind of understand whether or not there's actually been misconduct. We can reach out to third parties, and sometimes we reach out to paralegals and employees, people that may have information that we need. Attorneys are obligated to respond to us, so if your attorneys ever receive something from the OPC asking for a response, you might want to just remind them that they are obligated to respond to us. So if we determine that there was not a violation of the rules of professional conduct, we will dismiss the case. We can decline to prosecute it, meaning there perhaps was a technical violation, but it's been remedied in some way. Or we do what is called an NOIC, or Notice of Formal Complaint, which is a charging document that outlines the rules that we believe have been violated and the evidence that we have. After that, the case goes to a screening panel, which is a panel of 8 members of a Supreme Court Ethics and Discipline Committee. And it's basically an administrative hearing, and that panel decides what to do with the case. They can dismiss it. They can issue a caution, meaning, okay, we're going to close the case, but we're cautioning you in the future to not do this. They can refer it to diversion, which, for lack of a better explanation, is a plea in abeyance, meaning we will hold it pending the completion of certain requirements and then close the case as if it was closed to begin with. They can refer to professional counseling, which is a professionalism and civility board to counsel you on the standards of professionalism, and by you I mean your attorneys. They can give a private admonition. Do any of you read the Bar Journal? Okay. The back of it, there's our little disciplinary pages that are really exciting to read. Is that why you read it?
Straight to the back.
Yeah. That's the only reason I read it. So, well, I did before I started here. Now I know about them beforehand. It's always exciting. But they can issue the private admonition, which is an explanation of the conduct, of the misconduct, but without identifying information. The public reprimand includes identifying information. Or they can direct the OPC to file a formal complaint in district court, meaning the OPC will then file a civil suit against the attorney for their license, and it proceeds as any other civil matter. It proceeds in two phases, and hopefully none of your attorneys get to this point, but I don't know who your attorneys are. So it proceeds in 2 phases. The first is the adjudication phase, which is to determine which rules, if any, have been violated. And it's governed by the rules of civil procedure. After that phase, if there has been violation of the rules, it will then proceed to a sanctions phase where the court will determine discipline. And the court has the entire range of discipline available to them, from dismissal to disbarment. So they can also issue suspensions and probations and diversions, and I don't think they've ever given a caution, but they can dismiss it. I don't think they'd ever give a caution, actually. And we operate under rules. So these sanctions, and whether or not we ask for disbarment or suspension or public reprimand, they're all governed by rules and standards. So it's not like we are just arbitrarily throwing out disbarments and suspensions. So hopefully that gives you kind of a context of what our office does. So I'm going to get into the rules of professional conduct. And how many of you, just based on your own perception of yourself, think that you know the rules of professional conduct pretty well? How many of you know them at all? Like a couple? Okay. So these rules and knowing the rules are one of the best ways for you to keep your attorney out of trouble, because you'll understand the obligations that they have and you'll better understand your role in them. The rules are divided into 8 sections, dealing with different roles and relationships and places that attorneys operate in. And I'm not going to read all 8 because you can read them. Not all of these sections of rules are really pertinent to you as paralegals or assistants. Are you all paralegals, or some of you assistants? Is it all paralegals? Okay. Okay, so the first rule, and this is where my slides get really boring, but I'm hoping to have more discussion, and actually I'm not going to read these out loud. You can read them as I talk at you. So this rule, Rule 5.3, is perhaps the one that you want to know the most, because this is the obligation that attorneys have involving their non-lawyer assistants, which are you, the paralegals, and other staff members, but paralegals. They are obligated to have measures in place at the firm to ensure that their non-lawyer assistants that their conduct is compatible with the rules of professional conduct and the obligations of the attorney. If you have a direct supervising attorney, that attorney is obligated to supervise work in a way to ensure that the non-lawyer's conduct is compatible with the attorney's obligations. And then if you'll see provision C, and I will read this one, a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer, if the lawyer orders or with knowledge of the specific conduct ratifies the conduct, or the lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over the person, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. And that's the rule that makes your attorney perhaps liable for your conduct. If they ratify it or if they know about it at a time when they can remedy it, and they don't. So know this rule. And I just said that. So here are some case examples. They're hypotheticals, though they come from real life cases. So first one, the attorney asked the client, the attorney's staff, asked the client to provide the same documents multiple times. Various staff members asked the same questions multiple times of the client, and the case was delayed because of disorganization within the attorney's office. The attorney was not supervising the work of his staff members, and when the client called, like this says, would ask 4 or 5 times the same question, or would get asked the same question about documents to submit. And the case ultimately was resolved, but was delayed significantly because of that disorganization. When asked, the attorney said that he didn't even know who that client was, and all of the work had been delegated to the staff members. Case number 2, and this one's funny, because hopefully none of you do this. There was a paralegal that told a client that a hearing had been canceled, but the hearing was never scheduled in the first place. Now, this case resolved, the case in our office resolved prior to getting more information. The attorney says that he didn't know about, or he never told the paralegal to tell the client this, but that is up in the air. And in that case, he certainly would be responsible for the paralegal's actions. At the same time, regardless of whether or not he told the paralegal, there are obviously some supervision issues if the paralegal is out telling clients information that is incorrect. Case number 3, the attorney failed to supervise paralegals who were sending out billing statements without prior review or approval, and failed to follow up with them about pending cases. So the paralegals were just sending out information and billing statements kind of on their own prerogative, and did not have the attorney reviewing them prior. So let me ask you, and I'm doing this only because there are so few of you, and I feel like I am just talking at you, so I'm going to ask questions. But, so you as a paralegal, do you believe that that is a lack of supervision, or is that a paralegal problem?
Both.
Yeah, I agree. I think there are some issues with the paralegal thinking they have more authority than they do. It's also a attorney problem because they are not supervising or did not train the paralegals correctly. Hi. I know her. And then failure to follow up about pending cases. This is also not just in this case, but in a number of cases we see. The attorneys will kind of throw their paralegals on the bus, say, well, my paralegal was dealing with that, or my assistant was dealing with that. That does not absolve the attorney from being diligent in the case and there needs to be some more communication. So you as paralegals perhaps need to take some action and make a preemptive strike, I guess, and help your attorney stay up with the cases. And I don't know all the dynamics, and so I say that generally, but, okay. So are there questions right now about Rule 5.3, which is the rule you should know? Okay. Okay. So the next one, client confidentiality. And this is another one that you should be very familiar with because it's easy to violate this one. And basically it means that the lawyer is responsible for keeping information about the representation confidential. And if you'll, and again, I'm not going to read the whole rule, there are certain instances where the information can be disclosed, but I want you to read it with me. I will read it out loud. Provision C, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. So the attorney has to have measures in place to ensure that information going out from other parties other than the attorney, including the paralegals, remains confidential. Before I go to this, well, I did my slides right. So, what part do you play in that? More specifically, how can you violate client confidentiality as paralegals?
Accidentally forwarding an email that has discussion about strategy and things like that.
That's perhaps one of the number one things that we see happen is an email will be forwarded without reviewing the entire chain that goes with it, and there's discussion of things that shouldn't be disclosed.
How about sometimes staff people are in the elevator and they're talking about clients and stuff, and you don't know who else is riding the elevator, and that should not be discussed.
The elevator, the
Public
bathroom,
places.
yeah, at lunch, restaurants, yes. It's funny, the train does, yeah. No, it's almost a social experiment to go sit in a public place and listen to what you can hear. Because I think a lot of people forget that other people can hear you when you're in public. And there have been a couple times I've even had to stop myself when we've gone out to lunch as with some people in the office, and we have to stop ourselves because it's so easy to just sit and talk about things, and then you don't know who's in that restaurant or in the elevator or in the bathroom on their phones, which has happened at the bar building before. Okay. The next rule, 1.3 diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. So what part can you as paralegals play in getting your attorney in trouble with diligence?
Not following up with the attorney to make sure that they're staying on, with that particular client.
Yes.
Just, if there's a court hearing and not helping them update it accordingly in whatever mannerism they use for countering. There's a lot you can do.
Yeah, it's true, not following up, not helping your attorney follow up. What else do you think?
I think untimely, not telling the attorney in a good time what's happening, that somebody's called or there's an issue or they need to be made aware quickly.
Yeah, just kind of letting something sit on your desk for a second and waiting to get back to them. Yeah. There was a case in the office that, and again, the attorneys are ultimately responsible. So I talk to you as if you get in trouble, you don't, your attorney gets in trouble. But a client was asking for a refund of monies that had been paid that had not been earned. And the attorney told the paralegal to prepare the check and to send it out. And that paralegal just let it kind of sit on the desk for a month and a half. The attorney never followed up. The paralegal never sent it out. So the attorney got a bar complaint. It was resolved because the attorney figured out what happened. So yeah, letting things sit on your desk can get people in trouble. This is a interesting case. The attorney had some medical issues and some personal issues and basically left the entire case management and all of its tasks for the office in the hands of his paralegal and staff members. And that paralegal, because he then took over all of the cases in the office, failed to diligently pursue all of them, which one, he shouldn't have been doing in the first place, because there were some other unauthorized practice of law issues, which we'll get to in a minute. But secondly, one of these cases involved a statute of limitations that was rapidly coming to be, and the client missed that statute of limitations because his case file got lost in the file of someone else and was not found until a year and a half later after a bar complaint had come in. And through all of this, the attorney continued to tell our office that it was the paralegal, and that the paralegal had a lot to do, and the paralegal couldn't do this, and it ultimately is on the attorney. So if your attorney asks you to take over the entire case management, just kindly say no and perhaps find other employment, because it's not going to turn out well for anyone. Communication. This is another one that I've seen paralegals be involved in, is communication with clients and communication with third parties. So attorneys are obligated to A1, promptly inform client of decisions and circumstances that need the client's informed consent. A2, reasonably consult with the client about how the client wants the case to go forward. A3, keep the client reasonably informed about the status. 4, promptly comply with requests for information. And 5, consult with the client about limitations that the attorney may have because of his obligations or her obligations. And then B, provision B, is the attorney is obligated to explain the matter to the extent that the client can basically understand it. B, you should not be involved with because that's practicing law. But these A provisions, how could you get your attorney in trouble? We've kind of said a few of them, not telling them that the client is asking for information, which happens. A client will email a paralegal and say, I need to know this, or when am I needing to be in court, or I need a retainer refund, and the paralegal just doesn't pass it on. Yeah.
Sometimes clients feel closer to paralegals, or they feel like the attorney doesn't have time for me, or he's billing me so much. So they start prying or asking the paralegal questions like, what do you think happens and what will the judge say? And then the paralegal says, well, most of the time, and she's not, or she or he not supposed to be
Exactly.
saying or guessing or passing that kind of stuff on.
Yeah, exactly. And that is a huge point, and we're going to get to that, because there is a line between what you can and cannot say as paralegals, which hopefully you all know. I'm seeing nodding heads, which is good. It always scares me when you get the glazed over look. I'm like, I can't tell them. So yes, but the point you made at the beginning, where the paralegal becomes the client's kind of liaison to the attorney, that can cause some problems. Because then the client wants to get too comfortable with paralegal wants to get too comfortable with him, paralegal thinks they don't have to tell the attorney things, and then the attorney ends up not communicating with the client in the way that they should. Okay, this is why I asked the question at the beginning about how many of you deal with the trust accounts. I think, however, that it's important for paralegals and assistants in any regard to understand the obligations of an attorney's trust account, because our office gets a number of complaints about money, that it's important, I think, for everyone to understand these obligations. And it's a long rule, and I will summarize it. So a lawyer, as I said, is required, if they take money from clients, basically in retainers, or if they're taking settlement checks, they are obligated to keep money that is not theirs separate from their own property, which is why they set up an IOLTA account, attorney trust account. That trust account earns interest. That interest is paid to the Utah Bar Foundation that provides funding for access to justice and those type of programs. And banks are required to report overdrafts to us. So they are obligated to keep their property separate from client's property. They can deposit a small amount in that account of their own money for bank fees, but it has to be an amount solely necessary for those fees, not like $5,000, which people sometimes try and justify. They deposit into that account money that has not yet been earned, and they withdraw money only as it is earned, or it has to be paid to someone else. So you get a big settlement, and it goes to liens and stuff like that. When the lawyer receives money that someone else has an interest in, they need to notify promptly that person and deliver promptly to that person the money, so it's not just sitting there when it's belonging to someone else. They also, when an accounting is asked for, are obligated to send an accounting of the monies. And a lot of attorneys get in trouble with that because they don't account contemporaneously, and they have to go back and try and figure it out. And then if the money is in dispute, the money has to stay in the trust account, the disputed money, until that dispute is resolved. So these are big obligations. How many of you work with newer attorneys, like under 5 or 6 years? Anybody? Okay. And I don't know who they are, so this is another general statement because I remember myself as a new attorney and we were brain dead to trust accounting. Like, it is terrifying. When you're dealing with retainers and all this money and you see this rule and you don't want to be marked as someone who's misappropriated client funds, and they don't teach us this in law school, how to account for client money. So it's a big deal. So those of you who deal with the trust account specifically, but the rest of you, so what part do you play in keeping your attorney out of trouble with their money?
You do a good job when you accept the money, writing it out, letting whoever needs to know, so that it can be accounted for.
Mm-hmm. There was a case, and the next slide has examples, but this isn't on it, where there was a change in staff, and the new staff did not get trained, was not depositing checks, but was writing checks. So the account became overdrafted.
And we also have to make sure we're doing it the right account, because they'll have the regular checking account and then their trust account.
Right.
So it can easily get put in the wrong account.
Yeah, which happens a lot. They'll write a check from the trust account when they meant to write it from an operating account, and then it causes problems. Yeah, what else do you think? Do any of you deal with accounting? The actual writing the number, like keeping track? Okay.
It's a long time ago.
Long time ago, okay. Then I'm not gonna get too much into that, but that's another way to keep your attorney out of trouble. In the end, however, an attorney cannot be absolved by saying someone else is taking care of the accounting and it's their fault, because it's their trust account and they are responsible for that money and should be involved in that accounting. So again, if an attorney comes up to you and says, why don't you just take over the accounting and we'll call it good and update me every couple months, just walk away. Okay. I'm telling you all like leave your jobs, but that's not really what I mean. Because I don't have a job for you. Yeah.
I have a question, something like that, like we keep saying to walk away, but as a paralegal, do you get in trouble, or are there things that?
Well, you mean with our office?
Yeah, just with different things like that.
The only way that you could somehow get in trouble is if you're practicing law. The other issues we don't deal with. Like if you were to mess up the accounting, it falls on the attorney as far as we're concerned, because for some reason there wasn't supervision or there weren't measures in place. Beyond that though, if they want to come after you or if you're, I'll get into that in a second. If you're a licensed paralegal practitioner, one of these new ones, that's a whole different world. But as far as our office is concerned, no. Yes.
It was explained really early to me, attorneys can be disbarred, paralegals can be fired.
Yeah, that's a
So-
perfect way of putting it. Yeah. So you won't come to our office which is probably, please don't come and talk. No, you won't. And if you're practicing law as a non-lawyer, that goes to the general counsel of the bar. So we wouldn't like me to deal with you. That's a perfect way of putting it. Okay, so some examples where attorneys have gotten in trouble. And I put the 5.3A violation because that's how they come to violate the rules on behalf of their paralegals. Yeah, so this first one's basically what I said. The attorney relied completely on the staff for the accounting and only got updated once a month or when she was in town because she had offices, the attorney, I'm supposed to say the gender. The attorney had offices in 2 different states and would kind of go back and forth. And the accounting got completely out of whack and caused numerous overdrafts. It caused settlements to not be dispersed correctly. The next example, the attorney never interacted with the client, had never talked to the client had never talked to the attorney, and the attorney let the assistant handle everything. In fact, the attorney assumed that there was a trust account and that money was going into a trust account, and there was not. The case, the underlying case, so not in our office, but the case was abandoned, and the money that should have been a refund was not readily available to the client. And then the third example is the attorney didn't supervise the staff member who was only signing once. Most good attorneys, I should say, I don't even know if I should say that. It is best practice to have 2 people sign checks. An attorney should always be signing a check because they should be involved with that trust account. But this attorney failed to supervise a staff member who deposited a check with the endorsement of only 1 person, and then there was like a distribution of disputed funds. So there were funds held in the trust account that should not have gone out, that went out because that paralegal decided to send out a check that was unauthorized. So that's that rule. This is another one, and this happens a lot, and I will admit that it happens in our office on occasion simply because it happens, but it can be mitigated and perhaps avoided if you know the rule and if you pay attention. But attorneys, if they know that a party is represented by an attorney, cannot directly contact and communicate about the substance of the case with that person unless they have permission from the attorney. So, an example, and my next slide is a stupid question, we'll party play, so we'll go through that, but an example is an attorney sent out an initial letter to start a case, came back to his staff members that that party was represented. That information was never passed on to the attorney,